Now, Advocate Lamini, counsel for applicant number 3, correctly points out that applicant number 3 does have parental rights and responsibilities as protected in Section 21 of the Children's Act. There is no court order before this court that states otherwise. The 2 minor children have only one parent, and that is applicant number 3. To deny the applicant number 3's right to take care of his minor children will be an injustice to them, and this court will not go down that route. Now, the investigating officer provides a picture to the court of what exactly happened on the day of the incident. What is also worth noting is that the investigating officer suggests that it would be beneficial for the accused to be kept in custody as a measure to protect the applicants before this court. The affidavit is clear that there is an outcry and displeasure of the accused's conduct. To have a prominent pastor commit such a heinous act in the presence of minors, which he ought to have protected as he is their grandfather, has left the community angered. So much so, as the investigating officer stated in that the church, the applicant's number 1's church, has been burned to ashes. This is indicative of the anger of the community. Perhaps they could as well be paying for his blood. The affidavit of the investigating officer also shows that there are too many witnesses who were subjected to this ordeal, and what could also not lose sight of the fact that this incident occurred in a public school where minor children are enrolled at such school. The conduct of the applicant may as well have left the witnesses and learners traumatized. Now, Section 28, subsection 2 of the Constitution tells us that the fundamental point that the best interests of the child are of paramount importance, and as such, it is the duty of this court to protect children and ensure that they are protected in the environment where they receive education. This is not only in respect of the 2 minor children affected by this incident, but by the learners of the said school where this incident transpired. To be brandishing dangerous weapons and firearms in an environment and institute of learning, the court shuns the behavior of such. Now, in the case of S. vs. Shabalala, it was stated that the court must assess the appellant's future conduct in the light of existing or historical facts and circumstances. I cite this case in support of the factors listed in Section 60, subsection 4A to E of the Criminal Procedure Act. The court then must balance the right of the accused and those affected by the incident. Did the applicant discharge the onus placed on them? Do they satisfy this court with the evidence that they have placed before this court with the affidavit that they are suitable candidates for bail? Now, the only thing that this court must do is just to make sure that it's satisfied that all three applicants before this court, they can attend their case before this court. This is not the duty of this court to determine the guilt of the accused, as I've said. That's for the trial court to do. Now, it is quite unfortunate that the affidavits presented by the applicants before this court were not satisfactory, and simply they were just not giving of anything. The onus rests on them to demonstrate that they've adduced evidence that which are in the interest of justice to permit their release. The court has considered all angles and dissected the affidavits, and simply there is no indication that the said onus was discharged. This court is a creature of statute, and it does not operate on emotions and or influence. It is not a reactionary court, but simply deals with the facts presented before it. It is a creature of statutes and does not have inherent jurisdiction as that of the higher courts. So it simply can only do what is permitted to do within its own legislative framework. If the applicant fails to discharge the onus placed on them, then it is therefore clear then what should follow as a result thereof. The applicants did not have an obstacle of discharging the higher burden found in Schedule 6 bail applications. They simply needed to demonstrate to this court that the interest of justice permits their release, as opposed to the higher test found under Schedule 6 bail application. Their affidavits do not dispute that they are linked to the offenses preferred by the state. There is a strong case against them, and frankly, they did not put up a fight in ensuring that the evidence submitted by them hold enough water to discharge their owners. Now, I have expressed above that the investigating officer comes to the aid of applicant number 3. It is clear that the investigating officer has no reason why he is opposing the release of applicant number 3, and in the circumstances, the court must do what is fair and just. Applicant number 1, 2, and 3, please stand. Now, the court ultimately looks at what is presented before it, and it provides a value judgment from the said evidence. This court is persuaded that this case consists of so many probative factors which tips the scale in the respondent's favor. Now, in considering all the evidence before this court, the evaluation of the factors listed in Section 60, subsection 4 and 5 to 9 of the Criminal Procedure Act, applicant 1 and 2 have not discharged the onus that rests on them and have not adduced any evidence which has satisfied this court that it is in the interest of justice that they be admitted to bail. Applicant number 3, there is no basis that he should be detained until the finalization of this matter, and therefore the court shall grant his release from custody. So then the order is as follows. Applicant number 3, you are released on warning with the following conditions. You are to have no direct or indirect contact with the witnesses of this matter, save for the maternal grandmother and aunt under the guidance and assistance of the Children's Court. You are prohibited from entering the said school premises where this incident occurred up until the finalization of this matter. The court is aware that this condition, it will impede you exercising your parental rights and responsibilities, but this is only until the finalization of the matter, alternatively the outcome of the Children's Court matter. You are therefore warned to appear at the Knox Court date, and failure to do so, you may have your release on warning cancelled. And therefore, applicant number 1 and 2, your application for bail is hereby denied. Mr. Vilakazi, date? Date.
The court, or rather the state, is paying this court's indulgence, or should that maybe the state be granted a period of 2 months for the investigations, still ballistics outstanding and so forth.
I don't know. Then the date with the defense then. It will be for investigations, correct? The date, Advocate Dlamini?
Mr. General?
That is true, though. Your Worship, that's too long.
I don't know.
I understand, Your Worship. However, we're gonna get back to, we're gonna be in the same position, because if we get a shorter remand, we're gonna ask for postponement again for further investigations in any event.
How many?
Your Worship, 2 months. Accused number 1 and 2 in prison. That's completely situation where they are denied.
But the state is saying that they still need to investigate. And I'm sure with ballistic report, we know the situation at our criminal laboratories, that there's a backlog there. So surely that ballistic report is going to take quite some time. Hopefully it will be sped up.
Can I consult?
You may.
Your Worship, we will accept the state proposal, but we need a date, Your Worship.
Yes, you must provide me the date. Look at your diary and let me know.
Okay, indulgences. The 21st of October.
What day of the week is it?
Monday.
Is it suitable, Mr. Dlamini?
It's suitable, Your Worship.
Gentlemen, you then appear in District Court number 2. That's the reception court. On the 21st day of October for investigations. Accused number 1 and 2. Since your bail has been denied, you shall remain in custody. Accused number 3, you are released on warning with the condition that was set before this court. You are warned for 8:30 District Court number 2. If you don't come to court, a warrant of arrest will be authorized against you. 21 October, DC2, 8:30. I want to advise the gallery the court is still sitting. We have other matters, so if you're going to leave, please leave quietly. Yes, that's what I want you to say. The court is still sitting. I've got other matters to proceed with. So if you're going to leave, please leave quietly.
emelahlekweni sizenakhosi umthakathi nemzulu